All right? If you have a population that you're targeting, all right, that speaks Spanish, terms, conditions, delivery, everything like that also need to be conveyed in Spanish as well. Okay, but a lot of complaints in regard to how telephone and mail orders or email orders. Okay, now let's look at more narrowly looking at the telephone and mail order requirements. Okay, now let's say something goes bad. Okay, so let's say you bought it, doesn't matter who initiated the transaction, could be a telemarketer or you saw something on TV, had to have it. I remember a few years ago I had to buy, I saw on TV a commercial for AM Gold CDs and I had to buy those. I think I also bought Modern Rock, which is kind of like 80s music, which I love. It's nothing like classic rock, but or Motown, anything Motown's good. But nonetheless, so let's look at some of the rules that are specific if things go bad. All right, number one, the product does have to be delivered on time as promised. And number two, if that can't happen, all right, the consumer must be told when the product will be available, and that has to be within a reasonable time period. Now, many retailers, wholesalers, advertisers, marketers, what have you, have done a pretty good job in protecting themselves by saying 6 to 8 weeks for delivery. Right, so when I bought my AM Gold CDs or my Modern Rock CDs, I think I was told 6 to 8 weeks. I think I got one a month starting within 6 to 8 weeks. But nonetheless, they do a pretty good job. Now, if they tell people ahead of time that's what it is, then that's fine. Right? There's nothing to worry about there. Okay. Third, they have to provide a refund within a reasonable time period if the good can't be made available in a reasonable time period. Right? So the idea is we're not going to allow retailers, wholesalers, marketers, advertisers to keep your money hostage if you're the consumer and you have a real problem with your product. Okay? So again, deliver it on time as promised. If you can't do that, make it available fairly quickly, right? Or at least tell the consumer when it will be available. And then lastly, and probably most importantly for a lot of consumers, a refund has to be made within a reasonable time period if that good can't be delivered within a reasonable time period. We're not going to allow retailers, marketers, firms hold consumers' money hostage. Okay, now the Postal Reorganization Act of 1970 created one piece of mammoth protection for consumers. Now, the statute's a little bit of a misnomer. It was a big statute, did a lot of things. Number one, it did reorganize the Postal Service, as you can imagine. But the one thing it did is it took care of the problem whereby a marketer, retailer, wholesaler would send to a consumer an unsolicited package. Didn't know it was coming, didn't ask for it, didn't know what it was, but you open up the box and then there's language in there saying, congratulations, you've bought this, remit a check. And as an uninformed consumer, you're like, oh my gosh, what do I do? Okay? And most of the time, people are just writing a check, sending it in, and paying for it. Okay, this basically changed all that. If you get an unsolicited package with your name on it, didn't ask for it, didn't call in for it, didn't know it was coming, you can keep it, you can destroy it, you can give it away, you can do whatever it is that you want to do with it. Now, from the Postal Service's point of view, they were getting tired of dealing with this. But of course, Congress had the foresight at the time to realize that, yeah, you got a lot of consumers who are saying, what am I doing here? Yeah, I get all these products sent to me, I open it up, and I've been told I've bought it, right, in some way. And again, the uninformed consumer not knowing what their rights are. But I'm old enough, again, to remember when the federal government was actually engaged in public service announcements letting people know of these rights because it was such a problem. This was the early to mid 1970s that they were running these PSA, the public service announcements, letting people know, hey, if they send it to you, you can do whatever you want with it. You certainly don't have to pay for it. You can burn it, use it, give it, we're getting into the holiday season, Christmas, Hanukkah, right? If you get this stuff unsolicited, you just re-gift it, I guess. But nonetheless, all right, you can do whatever it is that you want with that particular product. And again, no penalty, no breach of contract if you decide not to buy it. And I would certainly suggest that you don't. Okay, now, Let's look at credit protection, okay? Now, these statutes are incredibly important, especially when we get to the last two. And what I like to tell students is that there are three very, very valuable things for your future. One is your education, two is your health, and three is your credit rating. If you have those three things, there is literally nothing that can stop you. And notice, for the most part, those are intangibles. Right? Your education, your health. Now, again, it's nice to have a healthy body. That's important. But your education, your health, and your credit rating. There's not much that can really stop you. So a lot of these statutes are designed to help protect your credit, right? And your credit score is everything. For those of you that might wind up working in the insurance industry, you know, credit is incredibly important when it comes to insurance. It's not just how many how many speeding tickets have you had, but also what's your credit rating when you're getting an insurance quote. Very important. Okay, so let's look at the biggest statute, the most important, which is the Truth in Lending Act of 1968. All right. Now, what it did is it created basically a huge disclosure law. All right. If any corporate entity is lending a consumer money or arranging for credit or extending credit, could be banks, community banks, savings and loans, insurance companies, you name it. They're lending money, all right? They're arranging for credit. They're extending credit. Any way, shape, or form, they must disclose literally everything. Interest rate, right? Maturity of the loan, frequency of payments, any penalties, right? Anything, all right? It has to be disclosed, all right? There are really no exceptions, okay? Now, what I am going to do, however, is exclude a couple of types of transactions from the Truth in Lending Act. One of these will probably make sense to you, but if I'm lending money to my friend, right? I'm just Jared Tudor. I work at Wayne College. I'm not a banker. I don't do, nothing like that. And I'm just lending money. Obviously, I don't have to adhere to the requirements of the Truth in Lending Act of 1968. All right, so that's kind of an easy one. But the second one I want to screen out are transactions between corporations. So if one bank is lending to another bank, the Truth in Lending Act does not play a role. This statute is only designed to protect consumers who are borrowing money from firms that basically do this, right? Banks, community banks, investment banks, insurance companies, etc. If they're in the business of doing this, then they have to disclose literally everything. Okay, now, if all terms and conditions are not disclosed, the consumer has the ability to rescind the contract and just get out of it. Okay, so if you wind up in this business, or if you're on the other side, you're a consumer, it's quite a bit of protection. If interest rates or annual percentage rates are not identified, maturity of the loan is not identified, prepayment penalties, I mean, all sorts of things. Contract rescission. Now, some courts have gone as far as saying, hey, you know what? You've been the victim of a violation of the Truth in Lending Act. We're going to allow you to borrow the money for free. So you can still borrow it, no interest paid. Okay, so again, a lot of protection. Okay, now you see on your outline there's a little note there on credit card transactions. Now, very recently, and when I mean recently, within the last 30 years, credit cards have become more a traditional use of payment. It used to be back before really the 1980s, the credit cards were kind of a go-to if you had to, right? You had no other way to do it. But now it's just so easy with electronic payment systems to use credit card or debit cards. Now, this particular rule that we're going to cover only applies, however, to credit cards. And basically what it does is it limits the credit card holder's liability for unauthorized transactions to $50. Okay, so let's say somebody steals your credit card or cooks up your credit card number, and again, this happens all the time. This happened to me a couple of years ago, where bad person, let's call him, criminal, right, is able to miraculously develop a 16-digit credit card number that also matches the expiration date of that credit card and the security code. If you have enough number generation, you can pull this off. Regardless, your liability is maxed at $50. So if they put $500 on your card, you're only responsible for $50. Okay. Now, most credit card companies, by the way, won't even make you pay that. They will waive that, assuming you make the call fairly quickly. And again, with alert systems being what they are and models being what they are, again, credit card companies have every bit the incentive to protect you from this, as they do themselves, because they also don't want to be out the $500 either. Okay. And certainly don't want criminals to, bad people to get good at this stuff either. So, okay, let's look at the Consumer Leasing Act of 1988. Now, this statute has a real interesting birth history, in the sense that we're right in the midst of a debate in this country on tax policy, with tax legislation being in front of the United States Congress, again passing the House, and the Senate's kind of kicking it around now. But the last real major overhaul was 1986, and one of the big changes back then was the end to the deduction of interest on a new car purchase. Now, today, probably what people are most familiar with is the interest deduction you get on your mortgage on up to 2 houses. But up until 1986, you could actually deduct the interest on a new car loan. And the purpose behind that tax rule was really just to get people to buy new cars, saying, hey, Uncle Sam is essentially going to subsidize, all taxpayers, of course, will subsidize some of the cost of obtaining a new car. Now, essentially, they did away with that in 1986, and when it happened shortly thereafter was an explosion in the leasing of car market. Okay, so leased cars everywhere, and it's a pretty healthy market today. It's curbed a little bit, especially with 0% financing becoming not so much the norm, but a very attractive seasonal reality for a lot of major car companies. Okay, but this statute basically protected people when they decided to lease cars. So just 2 years later, Congress creates a statute, which was actually an amendment to the Truth in Lending Act, giving people a little bit more protection. Now, it does have a narrow window in the sense that the lease has to be for more than 4 months with a total value of less than $25,000. So if you're leasing an uber expensive car, it's not going to be covered. If you're leasing a car for 2 months, it's not going to be covered. So they just tried to kind of create a box, if you will, of activity that would be protected in regard to leased cars. And again, most leasing contracts don't go above $25,000. Now, what does it protect you from? Basically, everything the Truth in Lending Act protected you in regard to. All terms and conditions. Annual percentage rate, basic interest rate, quoted interest rates, the maturity, any penalties, prepayment penalties, late penalties, all those kinds of things have to be incorporated in the lease agreement, right? And if it's not, unilateral contract rescission, right? The consumer can merely just say, I'm out, okay? Now, some courts have gone as far as doing just what you think. You get to lease the car, no penalties, no interest. They come up with a value. Okay. Now again, still a very important statute, even if the leasing of car market, if you will, is not as big as it once was. Okay. Now the next statute is a very, very important one, very near and dear to my heart. It is the Equal Credit Opportunity Act of 1974, and what it did is it protected classes of persons that were not getting fair treatment in credit practices. Okay? Now, either by stereotype or even by financial modeling. Okay? So in the sense that if credit firms develop models saying that this group isn't likely to pay their debts in comparison to this group, so we'll deny this group credit or charge them more for credit, that's illegal. Now, by the way, the modeling is still okay. Identifying consumer behavior based on group is okay. You can still do that, and it's still done. However, you cannot treat people differently based on what you think will happen, all things being equal. Okay, so essentially you cannot deny people credit or treat people differently in regard to credit practices on the account of race, religion, color, gender, national origin, age, or marital status. All right? So it looks like a lot of the categories that we talked about in regard to employment discrimination, right? Race, religion, color, gender, national origin, age, and marital status. Okay? Now, also as an addition, you cannot treat people differently based on the fact that their income comes from a government source. All right, that maybe they're part of some government program that gets them income, right? WIC or some other program designed to help people that need that kind of assistance, okay? Now, can you treat people differently on account of their credit score? Absolutely, and that's why those credit scores are so important now, all right? Because you can't treat people differently, and nor should you. I mean, it's clearly illegal, in my opinion. It would be unethical to do so, all right? Just based on consumer groups. Can you treat people differently based on their own history? Yes. On their demographic history? No. Based on their own history? Absolutely. Okay, so again, this is a huge anti-discrimination statute. Now, let's talk a little bit more about marital status and its provision here. All right, as you can imagine, you've probably heard, and again, I'm the son of a single mother that went through this kind of reality. Women were treated grossly different from their male counterparts, whereby signatures or co-signers were required from husbands or fathers or brothers, right? Saying we have to have a man in the picture somehow, okay? All illegal, all right? You cannot require, now by the way, it goes both ways. So just because I'm a male, the bank can't say, hey, you gotta have your wife's, your mother's, or your sister's, right, signature, okay? Now, can you require a co-signature based on credit score? Absolutely, you sure can. But that's treating somebody differently based on their own history, not based on their demographic group, okay? All right, so very important there. Now, the last thing I want to mention here when it comes to the 1974 statute is that you can treat people differently based on their income levels across all these groups. If somebody makes $150,000 a year and somebody makes only $50,000 a year, you can treat them differently. But again, that's income level. All right, not where they get their income from, okay, but their income level. So again, when you think about reporting your income and your credit rating, that's pretty much what's going to dominate everything. And it should, that's fine. There's nothing, I think, unethical about it, and it's certainly not illegal, okay? Okay, let's look at the Fair Credit Reporting Act of 1970. Okay, now credit reports are so incredibly important. You want to buy a house, you want to buy a car, you want to lease anything, you want to get a loan to go to school, something of that nature. If it's an unsubsidized loan or a private sector loan, again, to go to school. Interestingly enough, of course, the tax legislation that's being kicked around Washington right now actually might change a lot of how student loans are conducted. But nonetheless, we don't want credit reports going into the wrong hands, and certainly without permission. Okay, so this particular statute, the 1970 statute, basically says credit reports can only be released upon consent. Okay, so if you want to buy something on credit, you're going to fill out a credit application. That's okay, all right? Getting an insurance policy, that's certainly okay, all right? If for any other reason, and you're providing permission, that's okay. Or you just want your own copy, that's fine, right? You don't need a reason if you just want your own copy, okay? That's fine. So you want to buy something on credit, house, car, whatever, you fill out the credit application. Insurance policy, and again, as I'd made mention earlier, that insurance policy quotes are largely based on your credit, all right? Or if you just want your own copy, okay? Those are all voluntary requests for a credit report to be released. Okay, now there is one last situation whereby even if you don't want to give consent, a credit report can be released, and that's pursuant to a court order. All right, so cases involving divorce, child custody, things like that, credit reports can be released, especially when it comes to calculation of alimony or child support or something of that nature, the ability to do those things as well. But there are also some other circumstances. Okay, but if the court says, yeah, you got to turn it over, you got to turn it over. Okay, now still talking about the 1970 statute. All right, what happens if you're denied credit? Right? Well, the credit bureau that's being used by the firm, right? The firm that might extend you credit or allow you to buy something on credit, the firm that they're using, right, has to let you know. So if it's ABC Credit History, Inc., right, they have to let you know, okay? And two, related to that, if you're going to be charged more for credit, you have to be told by that credit agency. Okay? Now the latter is a little bit, if you're being denied, that's pretty obvious. If you're being charged more, that can be a little bit more difficult. There is a good faith requirement on the part of both the seller that's willing to sell on credit and the credit bureau to basically decide what is a little bit more in terms of pricing there. Okay? Now, the credit bureau certainly has to identify itself, so you can contact it to see if there's any inaccuracies. They got the wrong name, the wrong social security number, wrong birth date, that there should have been some error. So again, that credit entity, that credit bureau needs to let you know. Okay. All right. Again, we just don't want credit reports getting in the hands of people that shouldn't have them. Okay, let's look at the Fair Debt Collection Practices Act of 1977. Now, this is, again, I had made mention earlier that these last two statutes are probably the most important, maybe in the entire section of law here. But this one's kind of a biggie. All right, well, as the extension of credit certainly grew through the 1970s, there was the birth of credit collection agencies. And these collection agencies didn't have a whole lot of limitation in terms of how they could go about collecting a debt. Since 1977, there have been some limitations. Now, by the way, this statute only applies to business to consumer loans, right? Bank, credit union, savings and loan, lending to average person. So it does not apply to business or consumer to consumer. So if I'm just going to lend my buddy $50, none of this applies, right? Maybe it's kind of obvious, but it does cover the practices of debt collection firms that do this for compensation, right? They're going to take a flat fee for reclaiming a debt, or maybe take a percentage of the debt, something of that nature. And there's lots of these companies that do it. But what we're trying to do here with this statute is really kind of rein in the damage that could be done. Okay, certain limitations. All right, number one. Cannot contact the debtor at the debtor's place of work if the employer objects, right? Now notice I didn't say employee. The employee might object, but you know, the collection agency doesn't have to worry. But the employer, for whatever reason, says, hey, don't email, certainly don't call my employee while they're on the clock here, then you have to stop. Number two, you cannot make contact during inconvenient times, phone calls or door knocking at 3 a.m. Okay, next. And something like, I think you'd probably figure it out if you watched a lot of late night TV, or enough late night TV. All right, as soon as you let the debt collection agency know you're represented by an attorney, that's it. They can't contact you anymore. They can only contact the attorney. Now, attorneys, again, by the way, it's not the debt collection agencies that let you know this on late night television. It's actually the attorneys that will tell you this. But you know, they kind of make it say, you know, you need representation to protect yourself, and basically all the attorney's doing is just writing a letter saying, hey, this person's represented, which is okay. I mean, I think that's a good thing, because that gets you out of the middle of it, and the debt collection agency has to work with the attorney. Okay, you cannot contact third parties to collect the debt, except the following people. You can, as the collection agency, contact parents, spouses, and financial advisors if known. Now the financial advisor might be identified in the credit contract. Okay? You cannot harass. You cannot intimidate. Right? This is going to happen to you, right? In the phone call or the email or something of that nature. Okay? And lastly, you can't use any kind of false information. Okay? So if you want to, if you are a collection agency and you get into a dialogue with the debtor, what you tell them better be true. It certainly cannot be a lie. Okay. Now, lastly, and it's the one that probably most people miss. As soon as the debtor says, I'm just not going to pay this, that ends it. You can't talk to him anymore. Maybe even better and faster than getting counsel. Depends on probably the debt level, but nonetheless, as soon as you say, hey, I'm not paying this, all right, then it just basically goes down another road. Now, it may wind up going to court after that, and that's okay, but you can't contact anymore. Okay, now, the debt collection agency, once getting the contract to collect the debt on behalf of the creditor, they do have to send a validation notice, and the validation notice basically says within 5 days you have to respond or the process will continue, okay? Now, chances are you probably have mechanically a little bit more time than that, because no debt collection agency, nor does the creditor necessarily want to go out of their way and put something on your credit history, because that actually does cost them some money. So they'll probably give you a little bit of extra time, but they only have to give you 5 days. But again, they do have to give you 5 days if you're the debtor. Okay, let's look at consumer health and safety. Now, again, we spent a lot of time looking at product liability law. We spent a lot of time looking at contract law for the sale of goods. Okay, and this kind of makes us go full circle in regard to products, but again, looking at it from a preventive point of view. Let's look at the Food, Drug, and Cosmetic Act. Now, you can make an argument that this is the oldest statute, continuous statute still on the books, in other words, that protects consumers. Okay? Now, the Food, Drug, and Cosmetic Act covers just what you would think. You can ingest it, you can put it on your skin, put it in your hair, all sorts of those kinds of things. All right, it's not necessarily the toy that you're going to watch your kid play with, or your bicycle you're going to ride to work. All right, but nonetheless, anything you can ingest, put on your skin, medicines, prescription, non-prescription, over-the-counter, doesn't really matter. Okay, now the statute started and still does today with protections against contaminations, adulteration of food, drugs, that kind of thing. Also protects us against, it still does, against misbranding of drugs, pharmaceuticals, things of that nature. Okay? Now, however, the FDA, the Food and Drug Administration, which is charged with enforcing this statute, is much more concerned with safety and effectiveness of pharmaceuticals and safety of other things. All right, so if you think about safety of food, it's got to be safe. Safety of your shampoo and your conditioner and your shave cream and your shave lotion, things like that. All that stuff, of course, has to be safe. But pharmaceuticals, be they prescription or non-prescription, have to be both safe and effective. Now, safety is a bigger concern, admittedly. Effectiveness does not necessarily have to be effectiveness for everybody. It doesn't have to be effective for everybody, okay? But nonetheless, they have to be proved to be safe and effective before they're released out onto the market. Now, safety, again, the bigger issue, always safety, all right? Now, firms, of course, have to come up with studies on their own, studies that can be verified, all right, that they're reliable as well as valid, and those studies, of course, are sent to the FDA. The FDA does not do a lot of its own research, okay? They are much more concerned with what the product manufacturer, the pharmaceutical company, if you will, what they've put together, how they've studied the product, what were their methods, how often did they study it, did they study it on humans, did they study it on animals before humans, that kind of thing, okay? But nonetheless, when it comes to FDA violations, all right, there's a lot of strict liability. There isn't a whole lot of defense when it comes to adulteration of products, misbranding, again, the older functions, but also anything that might interfere with a product's safety or effectiveness. Okay. Now, one of the things that I think most of us think about today are really the level of carcinogens that you might find in your food products. Now, the FDA does require that those be identified, and if the FDA thinks they're just too much, they can take those products off the market. But again, what you can ingest, put on your skin, that type of thing. Prescription, non-prescription, doesn't really matter. Okay, and the last thing we want to look at tonight is the Consumer Product Safety Act. Now, this statute, again, has as its sole function making sure a product is safe before it gets on the shelf, before it gets into the stream of commerce. Okay, so if you buy something on the shelf, you're looking at it right there on the shelf, you can assume it's safe. All right, now if you're scratching your head saying, wow, that sounds a lot like an implied warranty, yes. Okay, if I buy it and it rips my face off, that sounds like a lot like product liability, yes. So could an injury based on a product that's not safe be a consumer protection violation, more specifically the Consumer Product Safety Act, a breach of contract, and product liability? The answer is yes to all three. Okay? Now again, if you buy it and you know it's dangerous, there are some problems, but it doesn't hurt you, might be also a breach of contract case, probably won't be a product liability case. Okay, now the Consumer Product Safety Act created the Consumer Product Safety Commission, and this is a group that has a lot of authority, all right? They can pull products off the market. Now think of yourself as a firm that spent a lot of money designing, creating, manufacturing a product, marketing it, advertising it, only to be so dangerous that the Consumer Product Safety Commission decides to take it off. Children's toys would be probably a classic example here. We find out the toy is just too dangerous, all right? The Consumer Product Safety Commission has the ability to remove it from the market. The Consumer Product Safety Commission also has the ability to initiate cease and desist orders in regard to advertising as well as sales, right? So is there a little bit of overlap when it comes to the advertising of products in regard to these two agencies we've talked about tonight, the Consumer Product Safety Commission and the Federal Trade Commission? The answer is absolutely. Okay, but again, if they get notice, and that's the thing, the Consumer Product Safety Commission, much like the FDA, they do not do a lot of their own research, all right? They rely on the product manufacturers to do research. Okay, they're not going to do a lot of it on their own, but if they get notice, they will act, and they will act quickly. Okay, well, thank you very much for listening tonight. That's consumer protection. Thank you.